Thank you, Mr. Chairman. Good to be here, and Mr. Cleland and Mr. Gorton, in particular, recall testifying before you when you were in the Senate too long ago. I'd like to acknowledge that the presence here today of family and friends who lost loved ones and colleagues on September 11th. And nothing we can do is going to diminish the pain in their hearts, but my hope is that the work of this commission will result in a sustained and permanent improvement in security. My testimony today is based on audits and criminal investigative work spanning a number of years, covering a broad range of aviation security subjects. Before my current job, I worked at the General Accounting Office and was testifying on aviation security at FAA as it existed in 1987. So I try to bring that perspective to bear. As you know, FAA had the responsibility for overseeing the security of the nation's aviation system before September 11th, and that responsibility transferred in November '01 to the Transportation Security Administration, and on March 1st of this year, the Transportation Security Administration was transferred to the Department of Homeland Security in what was, I think, the largest reorganization of government since World War II. At the outset, I think we believe that aviation security will require a continuous improvement and vigilance. There is no such thing as an end state in this business. But it's important to note that the aviation security that we have today is demonstrably, noticeably tighter than it was before September 11th. I think during the 16 months after the passage of that act, and at the direction under the leadership of Secretary Mineta, much has been accomplished. But I want to focus on the aviation security system in place before September 11th. I know that's the charge that you laid out, Mr. Chairman. I think that the system that we had in place before September 11th had, in fact, undergone incremental improvements over the years, especially in the last 5 or 6. And I believe that, in fact, provided a deterrent value for certain types of threats. Overall, though, the model on which the system was based did not work very well, and there were significant weaknesses in the protections it provided, even for the types of threats the system was designed to prevent. And as a result, that system has undergone fundamental change, or that model has undergone fundamental change. I'd like to speak to several attributes of that model, if I might. Before September 11th, the model was mostly based on reacting to known security threats instead of being proactive. That is to say that the security requirements that were in place were predicated largely on responding to threats that we had actually experienced. Example, screening checkpoint security came about as a direct result of the aircraft hijackings worldwide during the late 60s and 70s. In almost all those cases, guns were the weapon of choice for hijacking the plane, and you can see that reflected in the system. Airport access controls were further strengthened after the crash of Pacific Southwest Airlines flight 1771 in 1987. This was where an employee didn't have to go through the normal screening. He was a disgruntled, I think, ex-employee, smuggled a gun on board a plane, fatally shot his supervisor, the pilot, and co-pilot. And shortly thereafter, requirements designed to address that threat were implemented. Checked baggage security, as the chairman mentioned, was strengthened during the 90s after the bombing of Pan Am Flight 103, and I could go on. Security underlying that model and the assumptions on which the pre-9/11 aviation security model were predicated did not envision a scenario of commercial airliners being used as a weapon, or the use of box cutters by individuals who were prepared to die in the commission of their terrorist acts. Now, the model that we have, it dates back to the early 1970s. This is the pre-9/11 model. And it was implemented through a kind of an odd sense of an odd assortment of shared responsibilities. Industry provided and paid for the security, that is, the airlines and the airports. FAA's role was to establish the security requirements and ensure compliance with those requirements. We feel that within that model, there were strong, very strong counter pressures to control security costs. because it was a cost center for the airlines, and to also limit the impact of security requirements on aviation operations so that the industry could concentrate on its primary mission of moving passengers and aircraft. In our opinion, those counter pressures in turn manifested themselves as significant weaknesses in security that we, the GAO, others, including the FAA, repeatedly found during audits and investigative work. I'd like to mention some of them. And these were not new. I mean, they didn't just crop up before 9/11. They've been around for many years. First, screener performance. Air carriers were required to screen passengers in their carry-on baggage, and they would typically award the contract to the lowest bidder. Employees of these screening companies, they would typically get maybe 15 hours of training, and that was after an FAA regulation requiring it. They usually picked up the minimum wage. Our work has shown that it wasn't unusual for these screeners to be getting less money than the starting wages for an employee in a fast food restaurant right down the concourse. And those conditions, among others, resulted in screener turnover rates that in some airports were running about 400% a year. And that's going to translate into performance on the screener's part. So when we would go out and we would try to penetrate security at the FAA, going back nearly a decade, we'd find that the screeners would frequently fail to detect threat items, firearms, and mock explosives at security checkpoints. And I can't get into the details in an open session here, but suffice it to say, it was significant. GAO recommended performance standards for the screeners going back as far back as 1987. The FAA Reauthorization Act of 1996 directed FAA to issue a rule on certification of the screening companies, which in turn would result in standards for the screeners. And FAA first proposed the rule a year after that law was passed, but experienced various delays in the rulemaking process. And I'd just like to parenthetically note for the Commission here, I think the rulemaking process is one that's worthy of your scrutiny, and the role that cost-benefit analysis plays in the issuance of rules in our system of security. As it turned out, though, with respect to this rule, ironically, FAA was prepared to issue this final rule the week of September 10th, 2001. Another area, underutilization of explosive detection machines. In 1998, we found that air carriers were significantly underutilizing explosive detection machines. These machines cost the government about $1 million a copy. These machines were capable of screening 125 bags in an hour. They were certified by FAA at that rate. We routinely were finding that the vast majority were screening between 250 and 700 bags a day. Background investigation requirements. Criminal investigations that we conducted before and after September 11 showed serious weaknesses in the background checks of contract screener and airport workers. In October 2000, one of the nation's largest private security companies pled guilty to a felony, paid more than $1 million in fines and restitution for actually falsifying the criminal history checks and screener qualification records at one of our nation's major airports. This was not an isolated case. Before September 11th, little public attention was being given to that issue. After September 11, we participated in law enforcement sweeps at more than 30 airports nationwide, and those sweeps resulted in indictments or arrests of more than 1,000 individuals who had falsified records about their identities. Positive passenger bag match. For years, the carriers said that we can't do positive passenger bag match on domestic flights. It would be too costly. It'll bring the system to a standstill. It's now being done, and the system still seems to be working. Airport access controls. This is where you can, going down the concourse, you'll see doors. Those doors access into secure areas of the airport. During the late 90s, we successfully accessed secure areas in 68% of our tests at 8 major U.S. airports. And once we entered the secure areas, we were able to walk on the plane unchallenged 117 times. Cargo security is another area that I think is in need of some improvement. FAA made some improvements. I think some are still in order. Covert testing. I think it's very important in our system that we have covert testing employed to see how strong the security is. FAA standard protocols for testing how well screeners performed used carry-on bags with a firearm or fake bomb inside, and they didn't have much clutter. There wouldn't be much in that briefcase, and so you'd run it to the screen and it'd be, I don't know, to me it'd be kind of hard to miss. It was totally unlike techniques a saboteur or a terrorist might use. But FAA did establish an outfit called the Red Teams, which would, and I understand you're going to be taking some testimony from a former Red Team member later, they did use sophisticated testing techniques, and we would encourage the use of those. They also think that FAA covered up. There were allegations that FAA tried to cover up the results of the Red Team tests. We did an investigation. We did not find that they covered them up. We did find, though, that it was not effectively, that there was not effective follow-up in terms of permanent improvement.
You could wind up running ahead on time.
Yeah, and I would just like to close by saying that I think the new security model is based on very powerful lessons learned, but the more distance in time that passes between a security event and the current day, I think we all have to guard against complacency and pressures to relax security rules, even under the new model of security that's in place.